This is how you edit Bluebook citations of a case. This page includes footnote citations based on a law review write-on competition exercise. For this tutorial, I will just walk through the citations of the Sherman case, but note that there are many other errors to correct in the other footnotes. The first citation of the Sherman case appears in footnote 12. Rule 10.2.2 states that geographical units, such as states and countries, should be abbreviated based on table T10, but not if the geographical unit is the entire name of the party. So the US here should be spelled out as United States because it is the entire name of the party. Rule 6.2b2 states that superscripts should not be used in any case. So the superscript formatting should be removed from the RD in Third Circuit. Based on this same rule, the R should be omitted for ordinal numbers ending in 3, so third should be abbreviated as 3D. This case was decided in 1998 instead of 1997, so this typo should also be corrected. The case citation is part of the CEG citation sentence, so the Sherman case should provide support for the proposition that several courts have independently determined similar interpretations of the dynamic relationship between the plain language and legislative purpose canons. The citation includes a parenthetical that quotes material from the case. Based on Rule 1.5a2, the parenthetical correctly begins with a capital letter and concludes with a closing punctuation. The quote describes a Third Circuit court's interpretation of the relationship between the literal application of a statute and the intention of its drafters, which provides support for the above proposition. Thus, the CEG signal is correct. Rule 5.2e states that a quotation within a quotation should be attributed to its original source. This parenthetical quote quotes material from a different Third Circuit case, which quotes material from yet another case, but the citations omitted parenthetical is included here in lieu of a citation of the other cases. While Rule 1.5b indicates that the citations omitted parenthetical should be ordered before the explanatory parenthetical, the citations omitted refers to the quote inside the explanatory parenthetical instead of a quote from the proposition in the main body text above the line. Thus, I think including citations omitted inside the parenthetical seems reasonable, and I have not found a Bluebook rule exactly on point here. Rule 5.2 F2 states to alternate between double and single quotation marks for quotations within quotations. Here, there is a first quote within a second quote within a third quote. The third quote should use double quotation marks because it is the outermost quote. Then the second quote should use single quotation marks, and the first quote uses double quotation marks. Since the quote is from a specific page of the case, page 313, a pinpoint citation to page 313 should be added to this case citation. The second citation of the Sherman case appears in footnote 16. Rule 10.9 states that a short form for a case may be used if the case is already cited in one of the preceding 5 footnotes. The Sherman case was already cited in footnote 12, which is within the preceding 5 footnotes of footnote 16, so this short form is proper. But there is a typo because this should be the Federal Reporter 3rd instead of Federal Reporter 2nd. Also, the P period should be removed from the pinpoint citation because in the case short form, the specific page number should just follow the @. Rule 10.9a1 states that use of only one party's name in short form is permissible when the reference is ambiguous and it should be italicized. So the use of Sherman here is correct. And note that the comma after the case name should not be italicized. The but see signal means that the cited authority should clearly support a proposition contrary to the main proposition. However, footnote 16 is placed immediately after a quote in the main text. The Sherman case is the source of this quote, deceptive in its apparent clarity. So the but see signal should be replaced with a no signal. This quote is found on page 313 of the case instead of 314, so this typo should also be corrected. The third citation of the Sherman case appears in footnote 17. Based on Rule 10.9 and Rule 4.1, id short citation may be used when citing the immediately preceding authority only when the immediately preceding citation contains only one authority. Footnote 16 is the immediately preceding citation, which includes only the same Sherman case, so this short form citation should be replaced with id. Remember that id should always be italicized, including the period. The C signal means that the cited authority should clearly support the proposition. Within pages 313 through 315 of the Sherman case, there is a line that reads, despite the disjunctive phrasing in section 1623D, the New York statute it was based upon is drafted in the conjunctive. This clearly supports the proposition that the legislative history behind section 1623 provides strong support for why the statute is meant to be read in the conjunctive as opposed to the disjunctive. So the C signal is correct here. The fourth citation of the Sherman case appears in footnote 22. Based on Rule 10.9, when checking the preceding 5 footnotes to determine if short form for a case may be used, the previous case citation can be in either full citation or short citation. Since footnote 17 includes an id short citation to the Sherman case, and footnote 17 is in the preceding 5 footnotes of footnote 22, the case citation in footnote 22 should be in short form. So the United States should be removed, as well as the circuit, year parenthetical, and the first page of the case. At should also be added before the pinpoint citation to page 317. The contra signal means that the cited authority should directly state the contrary of the proposition. Page 317 of the Sherman case includes a line that reads, only if both statutory conditions exist at the time of recantation will Congress's dual purpose of deterring perjury through more effective prosecutions and encouraging truthful testimony be furthered. This line clearly supports, rather than contradicts, the proposition that Congress's intentions to deter perjury through facilitated prosecutions and to encourage truthful testimony cannot be realized unless both elements of the defense are met. So the contra signal should be replaced with a C signal here.